Good evening, everybody, and welcome to this webinar. Thank you all for giving us your time this evening. We're expecting about 30 odd people, so I'm just going to give it another minute or so and let some stragglers come in, and then in about a minute or so, we'll start. Just while we're waiting, my name is Ellie Pressman. My company is Barnet Wills, and I'm a local estate planner based in North London. Also with me tonight is going to be Brian Chipchase, who is going to talk a little bit about his area of expertise. I think we've got enough to get started. So let's crack on, and hopefully we'll all finish in good time. So what I'll do tonight is I'm just going to start with a little bit of basic housekeeping. Some of you will probably be familiar with Zoom meetings. Zoom webinar is a little bit different. And one of the things that you'll notice is that the chat box is actually disabled. So if you do have any questions, at the bottom of your screen, you should see a Q&A, and you can just type your questions into the Q&A box. And we will stop at various times to answer your questions. At the end of sort of each section. If we have time, we'll obviously, Brian and I will hang around at the end of the webinar and answer any questions. But if we don't get time to answer all your questions, then I promise we will actually respond by email to all those questions we haven't got through through the course of the evening. So let me just run through the agenda. It is quite a short one. We're going to start off with me talking about wills, what they do, and more importantly, what they don't do. Brian will then come in and talk about income protection and life insurance. And then I'll finish off by talking about the importance of lasting powers of attorney. Because of the time constraints, I'm going to actually assume that there isn't anybody attending tonight that thinks having a will is a bad idea and that it's okay not to have one. And we're all on the same page that we think that having a will is a good idea. But if anyone thinks that it's not a good idea, I'm happy to have a chat with you privately another time. So let me start by talking about wills. Now, I'm going to make an apology to start with. My virtual clients, Bill and Vera, I am going with a traditional sort of husband and wife, but the rules still apply to people in a civil partnership, same-sex marriages. So it's just for the purposes of tonight's webinar, I'm just going to go with Bill and Vera. So here is a typical scenario. Bill goes along to the local solicitor and he says, I'd like to make a will, please. Now, very often what happens is that the solicitor, or perhaps the will writer is invited into his home, will say, absolutely, Bill, no problem at all. You've come to the right place. What would you like to do? And I always find this a bit strange because he hasn't asked any questions and really there's not been a lot of advice given there. And so the solicitor or the will writer has kind of assumed that Bill's the expert. He obviously knows what he needs or what he wants. And all I need to do is draft it. But Bill isn't an expert in his field. And so what Bill does when confronted with that question is what 95% of people do. And he'll say, look, you know, when I die, I want everything to go to my wife, Vera. And then when she dies, I want everything to go equally to the children. And that is really what I call, or not what I call, what is a standard or basic will. And usually the spouse will have a mirror will, leaving everything to the husband and then equally to the children. So what can possibly go wrong? Well, let me tell you about a couple called Arthur and Jenny, who have been married for about nearly 40 odd years. They've got two children, Mark and Andrew, or Andrew and Mark in this case. And Mark is married to Alison. Now, when Jenny was in her mid to late 40s, she developed dementia or the early signs of dementia. And by the time that she was in her early to mid 50s, it had gotten so bad that Arthur decided that he would take early retirement so he could look after her full time at home. But sadly, about a year or so later, Arthur died after having a heart attack. Now, Mark and Andrew obviously couldn't give their mum the same level of care that their dad had done. And so really they sort of got together and decided that the best thing for their mum was to receive some specialist treatment or go into residential care into a home that specialised in dementia patients. Okay, I should mention that under the terms of Arthur's will, obviously the entire estate passed to Jenny. So Jenny then gets put into a care home. And this is really where the problem started. Because there wasn't a lot of cash in the estate, most of that £750,000 was actually the family home. And so the local authority actually forced the sale of Jenny and Arthur's home to cover the cost of her care fees. Now, it's estimated that between 60 and 70,000 people every year are having their homes forcibly sold by local authorities to cover their cost of care fees. So when Jenny died about 4 or 5 years later, over half the money had been spent. There was only £360,000, which was split equally under the terms of her will between her two boys. Mark was actually in the midst of a divorce. So within 7 months, he waved bye-bye to 90,000 of his 180 because Alison divorced him and she took half of everything, including half of his inheritance. Andrew wasn't so lucky. Andrew had a business. He was in debt to the tune of nearly £250,000. So as soon as his creditors found out that he'd come into money, you can imagine they were all over it. So Andrew actually ended up with absolutely nothing. So despite having perfectly drafted wills, only 90,000, the 90,000 that Mark had, out of 750,000 ended up where it was supposed to. That is just 12% of Arthur and Jenny's estate. The other 88% has ended up in the wrong hands. Half with the local authority, 90,000 with Alison, and 180,000 with Andrew's creditors. Clearly, this is not what Arthur and Jenny would have anticipated or wanted. And, you know, they are probably rolling around in their graves, you know, cursing the solicitor or will writer who drafted the wills, not because he lost them 660,000, which he did, but because they weren't even made aware of the risks or the potential risk that these things could actually happen. Had they known, they'd have had a fighting chance to do something about it. In fact, with some proper planning, it could have all have been avoided. So really, this case illustrates 3 of the main threats to your money. We've covered care fees, divorce, creditors and bankruptcy. And they are very common, much more common than people actually realize. But actually, there is one other way that is even more common where people lose their money. And before you all go mad in the Q&A, it's not tax. So here, these are some of the high-profile cases that have appeared in the newspapers. But if you look at the bottom middle there, the chap sitting on Southend Beach is a chap called Stuart Hurd. And really, the story goes back to his parents. Now, Stuart has been on the BBC. He's been in several newspapers. He's also been on 2 or 3 radio stations. He's sort of on a one-man mission to try and make mirror wills illegal. That's the strength or the depth of his feeling. So let me tell you his story. And if you ever go to my website, you can actually hear in his own words him telling the website where I've got a video of him. But the story really starts with Stuart's father, William. Okay, after Stuart's mother, Frida, passed away, Stuart's father, sometime afterwards, met a new lady, Dorothy. And after a short, I suppose, dating or romance, they got married and relocated to Wigan. Realizing or knowing that because they got married, their previous wills were revoked, they went to quite a substantial firm of solicitors in Wigan. We're talking sort of 8 or 10 partners with about 30, 40 support staff. So a reasonably sized firm, and said, "We've just got married. We'd like to make new wills, please." And the solicitor said to them, absolutely no problem at all. You've come to the right place. What would you like to do? Again, William isn't an expert. And he said, well, we all know now that people say, he said, well, look, if I die first, I want everything to go to my wife, Dorothy. And when Dorothy dies, it should be split equally between my son, Stuart, and Dorothy's son, Michael. And if Dorothy dies first, then it should all come to me. And then when I die, it will go equally to my son, Stuart, and Dorothy's son, Michael. And that is what the solicitor drafted. That's what they had signed. And they were very happy that everything was as it should be. Sadly, William dies first, and under the terms of his will, everything passes to Dorothy. When Dorothy passes away about 5 or 6 years later, Stuart discovers to his horror that, no sooner had his dad been buried, the first thing Dorothy did was she went back to the solicitor and she changed her own will, leaving everything to her son Michael and completely disinheriting Stuart from his share of the estate. And really what upsets him more than anything is that a lot of the money that he was anticipating getting from his father had been handed down to his father from his grandparents, and some of that had been handed down to his grandparents from his great-grandparents. So several generations of hard work and savings and graft have, with a simple stroke of a pen, ended up in the hands of a complete stranger, right? Michael, who Stuart had only ever met twice in his life, once at his father's funeral and once at Dorothy's funeral. And really, he was also anticipating using some of that money to give to his own daughter to help her get on the property ladder. So this disinheritance actually caused him to break a promise to his daughter to help her out, which is obviously one of the reasons he's so anti these types of wills. So those are the two case studies. So let me just have a quick recap. So these are the threats to your wealth. Okay, so on first death, right, when the money passes to the surviving spouse, the money's at risk from long-term care fees. If your spouse goes into long-term care, the local authority can go after all the money. And if you don't have cash, they'll go after your assets and your home. If your surviving spouse remarries and then either gets divorced, that's half the money lost, or even worse, if the surviving spouse dies before the new partner, as in the case with William and Dorothy, then everything could be lost. And, if your surviving partner, grieves and ends up with a drinking or gambling problem or whatever happens, has issues with creditors and bankruptcy, all the money could then be lost. If the money manages to run that gauntlet and ends up going to the children, then on second death, there are still risks. So if your children suffer divorce, then half the money, half of everything you've worked hard for that you've passed on could be lost in that divorce settlement. If they have issues with creditors or bankruptcy, as in Andrew's case, all of the money could be lost. Maybe if your children need long-term care in the future, that money could be lost as well. And lastly, inheritance tax. Now, inheritance tax there I've put is generational. What I mean by generational is that each time the money passes from one generation to the next, it inflates or adds to the estate of the beneficiary and could be taxed. So I've just had this recently with a client of mine that I went to see in December. It was up here in North London Hospice. I had a 67-year-old chap who unfortunately was suffering with terminal cancer, and he was getting his affairs in order. It was a little bit uncomfortable. It was sort of deathbed planning. And he drafted a will to leave everything to his own two children. And sadly, he passed away about 2 weeks later. But about 7 months before he died, his 93-year-old mother passed away. Now, she had an estate of about £1 million. She was divorced. So there was an inheritance tax bill on her estate. And in round figures, it was about £200,000. That means that my client stood to inherit £800,000. But his mother's estate, actually, even today, still hasn't finished going through probate. So the money hasn't been released. So when the grant of probate is finally given, that money will now pass to his children, her grandchildren. But because it passes through his estate, it picks up another £320,000 inheritance tax. So the grandkids are going to end up receiving 480,000 when it could have been 800,000. Now, obviously, the time frame between passing from you to your children and then from your children to your grandchildren, we hope in normal cases is a lot more than 6 or 7 months. But the effect is exactly the same. When the money passes at every generation, usually we hope that the beneficiaries have by then bought their own properties, they've built up their own wealth, so their allowances are already usually taken care of. So any money that's inherited is usually taxed at the full rate. So I hear you ask, how can we do something about this? How can we protect and make sure that the money ends up going where it's supposed to and can't be lost? Well, the solution is something called a trust. You can actually protect your assets by drafting a will actually into your trust. Sorry, drafting a trust into your will. Now, what is a trust? Well, it's nothing more really than a legal obligation where the trustees manage the trust assets on behalf of the chosen beneficiary. So we're just taking a little piece of law and wrapping it around your money to ring fence it so that only the people that you stipulate can actually benefit from that. What can you put into a trust? Well, the short answer is pretty much anything. You can put your house, cash, investments, your insurance policies, your factories, your farms, pretty much anything of value. In fact, I've even got one client who is considering putting a racehorse into trust. Trusts are not anything new, and there is a bit of a misconception that they are only for the very rich and the very wealthy or the landowners, and that's simply not the case. They really started to gain popularity much more in the days of Margaret Thatcher when she introduced the right to buy scheme. Suddenly people actually had something worth protecting. They were buying their homes and they had assets that were worth protecting. And since then, really, the use of trust has actually been growing steadily. But they've been around since the 11th century. Trusts really first started back in the Crusades when the knights would go off and they would give the keys, figuratively speaking, to their castles and their lands. And they would say to their trusted friend, look after my lands. If I don't make it back from the war, make sure my family looked after. And that's really how they were born. Now, trust you can set up either while you're alive. So if you have a property and you're worried about care fees and you want to put your property into trust tomorrow, you can do so. Or you can do it when you're dead, which means that the trust is actually drafted into the will. So the trust actually doesn't come to life until after someone dies through the will. I'm now going to give you some trust basics. So first of all, the person who creates a trust is referred to as a settlor. So obviously anything you put into a trust is a settlement. The trust property, well, that's what you put in. So that's either your property, your cash, everything you've got at the time of death. If you set up a trust in your lifetime, it can be set up with just a minimum of £10 and you can put more assets and money into it later on. Then you've got your trustees. So these are the people that you choose to manage your trust. Typically, that's going to be your surviving partner and probably adult children. Although in some cases, it can be other family members or even a professional if that is actually necessary. And then you have the beneficiaries. So these are the people that you want to benefit from your trust. So that would be, again, your surviving spouse, your partner, your children, grandchildren, and so on. Generally speaking, most trusts will exclude you as a beneficiary of your own trust. You're doing it for the benefit of others. Obviously, if it's through a will, the settlor is deceased, so that's not an issue. But in some cases, there may be a reason for having a trust that you are your own beneficiary. For example, if you want to put a property into trust to get it out of your estate for probate and care fees, you can be a beneficiary of your own trust. It's not IHT efficient. The taxman will still tax you on it in terms of inheritance tax, but at least you know that the local authority can't get their hands on it. And then the next question really is, how do the trustees know how, when, and which beneficiary should actually get what? Well, that's come through a document called the Memorandum of Wishes. It's a non-legally binding document from you, the settlor, to your trustees. It's your guidance telling them what your wishes are and how you want your trust to be run. So let's actually have a look at how this works in practice. So here's Bill. He went to his solicitor. No, he didn't. He came to me and he got some advice, and he had a will and he had a trust in it. And when he died, £320,000 was settled into his trust on his death. The trust was set up for his wife Vera and his 4 children. And Vera was the trustee, and he could have had any one or all of the children or even a professional as additional trustees if he actually wanted to. Okay, so here we go. Bill dies. Vera gets remarried. She's now got a new man in her life, just like William did. So the question is how much of Bill's trust fund is now attackable by Vera's new husband? Before you all jump into the question and answers, the answer there is 0. Okay, Bill's son John, he gets divorced. So how much of the trust fund is at risk from John's divorce? Same position as Mark, really. Well, it's not, because Bill had a trust. So in this case, the daughter-in-law is entitled to anything. Poor old Sharon, you know, she had her own business, but the pandemic, you know, really had its toll. And in the end, she went bankrupt. She couldn't run the business anymore, and she had to wind it up. How much of her trust fund is at risk from her creditors? You're seeing a pattern here, I can tell. Alex goes into care. So how much of the trust fund is at risk from Alex's care fees? The local authority will obviously want to get hands on any money that Alex is entitled to. But again, they can't. And lastly, poor old Kate. Well, Kate dies. How much of the trust fund is actually part of Kate's estate for the purposes of calculating inheritance tax to Bill's grandchildren? The answer there is 0. Okay, so I'm actually going to just talk about a couple of real life cases. Here we've got Mr. and Mrs. F. They own their home jointly. And when I came to see them, what we did was we equalized their estate. So we severed the tenancy so that they owned as tenants in common. And we created 2 wills with some will trusts for each of them. And in fact, they and their adult children were the trustees and the executors. Mr. F died in November 2016, and under the terms of his will, everything passed into his trust. A few months later, Mrs. F requires care, and the local authority wrote her suggesting that she had to pay her own care fees. So her daughter was very distressed because the letters from the local authority were actually quite threatening in nature, and they really were sort of quite frightening. And so her daughter contacted me for advice because I'd set up the wills for her mum and dad. So I reassured her that the planning would work, and armed with that knowledge, she contacted the local authority. There was no need to write to them. And she's now obviously more confident in dealing with them, having spoken to me. And after speaking to them, their financial assessment team actually confirmed that the house would now be disregarded and mum wouldn't be allowed or wouldn't have to for the sale of the house. Obviously, that was fantastic news for her, if not very surprising to me. Case number 2, this is Mrs. S. She was single. And she was worried about care fees. And so what we did was we decided to settle her house into a property trust. So she did that. She set up a property trust and conveyed a house into it. About a year later, she had to go into care. The local authority decided to write, again, in a very threatening manner to her and to the trustees, because they wanted to get their hands on her house in order to force itself to pay for her care fees. We wrote back several times. There was about 3 or 4 letters being written, and in the end, they decided that actually the planning stood. She didn't deliberately deprive herself of any assets for the purpose of avoiding care fees. The reason she actually put the property into trust was for tax reasons and to avoid probate. So timing is very crucial. But if at the time you do it, you don't need care, the planning will hold and the local authority won't be able to get their hands on your house. Right, that's it. Okay, so I'm now going to cover lasting powers of attorney. And I just want to relate a very quick story before I start, because not long ago, I had a client of mine who told me about their mum, Mary. Now, Mary had, unfortunately, a stroke and was in a coma for about 4.5 to 5 months. During that time, they weren't able to cancel, or the mobile phone company refused to cancel her mobile phone contract. She had private health insurance, but the family weren't able to make a claim. And the bank refused to cancel any redundant direct debits. So over that course of that 4.5, 5 months, Mary's finances became a total mess. Now, all these institutions didn't do anything wrong, either contractually or morally. Obviously, if you've got contracts with banks or accounts, you don't want anyone having access to those without properly documented permission. And that's really what lasting powers of attorney are. So, and that's why they are such important documents. So let's talk a little bit about them. First of all, there are 2 different types of powers of attorney. There is the health and welfare and the finance and property. And I will start by talking about the health and welfare. And really, the situation is that if a client, or if you were to lose capacity, then nobody has a legal right to make decisions about your care, about what way you should be treated, what treatment you should or shouldn't have. Okay. It's very important to understand in this context of powers of attorney, there is no such thing as next of kin. Nobody has a right to make decisions for you. Okay, that will fall on either the local authority and the medical profession. So without an LPA, your family, your dear ones who know you best, know what you want, can't make decisions about the treatment you should or shouldn't have, where you should be cared for, your diet, your routine, who should visit you, etc. And that right through to the DNR, the life-sustaining treatment, okay, or the withdrawal, I should say, of life-sustaining treatment, okay. Attorneys cannot compel a doctor to do something that the doctor does not want to do, or that's not beneficial to the donor, but they can withdraw treatment. So, for example, I had a client who dad had terminal prostate cancer, and also he had dementia. Now, as part of his cancer treatment, he would have to go every week for an injection. And the problem was that, because of his dementia, he didn't understand when he was at the hospital what was going on and why he was having these injections. And so after each injection, after each treatment, he became very distressed, agitated, and out of sorts for sometimes 3 or 4 days. So at least half the time he was in a very sort of distressed state. And so in the end, daughter thought, well, you know what, if the cancer doesn't get him, the dementia will. And so she decided that she didn't really want to see dad suffering anymore. And so she asked the doctors to withdraw treatment. At this point, the doctor said, well, actually, no, we don't want to do that. That's not our job. Our job is to keep him alive as best we can. And so at this point, she said, well, actually, I've got power of attorney for dad. I can make the decisions, and I know and I understand it may shorten his life, but at least that shorter time he'll have a better quality of life, and therefore the treatment has to stop. And because she had that power of attorney document, the doctors were able to, or the doctors had to comply. So you can't compel them to do something they don't want to do, but you can withdraw treatment that they want to keep on giving. The property and finance LPA, that is to do with obviously the financial matters. And that means that without it, it's going to be difficult for anybody to handle any of your finances, whether that's buying and selling your properties, paying your bills, collecting money you're owed, arranging insurances, claiming benefits, investing money, and so on. Okay. Again, dealing with HMRC, all these sort of things. So anything to do with your finances, without a power of attorney in place, nobody has the legal right to manage them for you. And again, that also includes the spouse. And I noticed very recently on TV, Kate Garraway from This Morning has been very public about the fact that since her husband got COVID, she has been locked out of his bank accounts and so on, which leads me into something that's very important. Okay, if we actually have a look at the British Bankers Association, when it comes to joint accounts, and most people are actually unaware of this, that if there is a joint account and one of the signatures on that account loses capacity, generally speaking, the banks will freeze those accounts because they now have a vulnerable person and they do not know whether that person would actually consent to those withdrawals. And so rather than get sued by relatives and other people, they will actually freeze that account. And that actually also applies to business accounts. So if you're in business and you have a joint account where you and your business partners are signatories to the account, imagine the impact if the banks actually froze that business account. You now have no way of paying staff, of paying suppliers, of dealing with invoices or anything like that, and that can sometimes cripple a company. So it's very important that where you have a joint account and there's more than one signature, without a power of attorney in place, and someone with lose capacity, you are going to be in big trouble. So what's the solution? Well, the solution is a lasting power of attorney document. It's a legal document where you appoint people that you trust to do exactly what you want and to make decisions on your behalf. Obviously, now in the current climate with COVID, with lots of vulnerable people and elderly people who are shielding and social distancing, there's been a marked increase in uptake of LPAs as a result, because more people are now being aware. So these are really important documents. Okay. In order to take out a lasting power of attorney, you have to have capacity, right? If someone has developed dementia, it is then going to be too late. Okay, so it's very important. You can only do this while you have capacity to do it. It's a little bit like arranging an overdraft. You do it in advance of when you need it. And the most important thing, these are very powerful documents. So it's crucial that you choose the right attorneys, the people that you trust to do what you want and to look after you in the way that you would want to be looked after. So typically these are usually family members. There are certain things that attorneys cannot do under an LPA. They can't make large gifts, they can't manage discretionary funds, they can't pay themselves a fee for doing it, they can't purchase your house from you at a reduced rate, they don't do tax planning, and most importantly, they cannot use their position to benefit themselves. Obviously, an attorney is somebody that's taking out an LPA to manage your money for your behalf. I noticed somebody saying in the question and answers that actually can't you do it free online at the Office of the Public Guardian? And the short answer is yes, you can actually go online and do one of these documents for free. But I would say that when you're dealing with someone like myself, you're not paying me to fill in the form. You're paying because I give advice. If you're filling in a form online, you cannot ask that form questions. And even if you could ask that form questions, you probably don't know what questions to ask because you don't know what you don't know. And there are things that I will put in there as standard, which you wouldn't have. And you can sometimes end up with a LPA that in some cases can't be fit for purpose. And the second one on that list, managed discretionary funds, that's actually quite an important one, because I had clients, brother and sister, whose dad had dementia. They had LPAs that they did themselves. And when dad's dementia got so bad that he couldn't be left alone, what they did was, as attorneys, they sold dad's house and they moved him into a cottage next door to the daughter, and she put the money in the bank. And they were doing everything absolutely right. They were using dad's money to look after dad, right? But they soon realized that actually, although he had dementia, physically he was actually in decent shape, and it was very likely that he would outlive his money. And then the financial burden would fall on them, and that would actually be very difficult for them. And so what they wanted to do was they actually wanted to get a higher return on that money. They wanted to invest it and place it somewhere where they could get a higher return. And so they contacted their independent financial advisor, and then they discovered, well, actually, they're not allowed to do it. A power of attorney does not allow attorneys to delegate to a third party. So the advisor, under the Financial Conduct Authority rules, wasn't allowed to take instructions from anybody other than the client, who now has dementia and so can't instruct him. So for people who have funds under management with their financial advisors, who have discretionary funds, or ISAs that are being managed, if you lose capacity, your attorneys cannot any longer give instructions to your advisors. So it's actually very important that these things are put in there. And I deal with a lot of advisors and IFAs who make sure that when they contact me to make sure that their clients have these documents in place so that they continue to manage the funds for their clients. So it actually is very, very important. But if you haven't got an LPA, what are your options? Well, unfortunately, if you don't have a lasting power of attorney in place, then the only option you have is something called deputyship, to go to the Court of Protection and apply for a deputyship order, because if you lost capacity, LPA is no longer an option. So to gain legal right to look after either someone's finances or make decisions about their health and welfare, you're going to have to go through the courts. And I'm telling you that it's not cheap, okay? To bring an application to the court costs in the region of just under £4,500, and that won't include the ongoing costs involving a solicitor, because the chances of you being able to do everything yourself are pretty slim. And even if you do get a deputyship order, there are ongoing costs, and not only that, it is actually quite onerous, okay? If the courts do grant you a deputyship order, there is ongoing supervision by the courts, okay? They may place limits on the checks or the size of the checks that you can write. They are constantly looking over your shoulder. They're going to ask you to account for every penny you spend and why. They could just give you a surprise visit, and so on. So it really is important to make sure that if you don't want the grief of all that, and the time and the expense, that you get an LPA in place sooner rather than later. So what are the consequences if you don't have an LPA? Well, some of you may remember Betty Figg. This was a case that made headlines in the national newspapers. Betty was an 83-year-old dementia patient. She was actually in a private home, but it was funded by the local authority. Now, her daughter, Rosalind, in fact, she had two daughters, but the prime instigator was Rosalind, was very unhappy with the level of care that her mother was getting. She would go to visit her in the care home, and Betty would pick up a glass of, a plastic cup of water, and her hands would be shaking and so on. And so Rosalind decided that really she didn't want this to continue any longer, and she sold her business, and she converted part of the downstairs of her own home, and she put in a new bedroom with an ensuite wet room. She put in guards and rails and all sorts of protections, and she brought her mum home. And within about half an hour of bringing mum home, mum was sitting in the kitchen, chatting away, happily drinking tea out of a cup and saucer, a china cup and saucer. 48 hours after bringing her mum home, there was a knock at the door. Rosalind opens the door, and she's confronted with two social workers backed up by six, no less than six big, burly police officers with a battering ram ready to smash her door down if she hadn't opened. And they literally barged past her and physically removed the old lady from her home. And that's really what made the headlines. There were neighbours out in the street with their mobile phones. They had all the commotion, and so everybody was filming it on their mobile phones. And what the social workers did to, further take away the lady's dignity is they put a tea towel over her head so she wouldn't be recognised. They bundled into the car, and in their haste to get away from the photography, they actually, when they were speeding away, they actually clipped a bollard or a lamppost, even further endangering the old lady's, her life, really. And so really, without an LPA, or if there'd been an LPA in place, all that heartache, all that aggravation could have been avoided. If Betty had given her daughter's power of attorney, they could have made decisions about their mum, and they wouldn't have had to go to court, which they did do. And it was a 7-month battle in which Rosalind did win, and Betty was allowed to come home. But obviously, there was quite an expensive process there of going to court. These were 2 other cases, again, quite recent, in the last year on the BBC, both similar circumstances. The one on the left, Paul Briggs was a serving police officer in the Merseyside Police, suffered brain damage after having a motorbike accident on the way to work. And the chap on the right, Bradley Visser, suffered brain damage after coming off a motorised scooter. On the left, Paul did not have a power of attorney in place, and therefore, when the doctors said there was nothing more that can be done, his wife, his mother, they all said, right, well, let him die with dignity. This is not how Paul would have wanted. One of the key people in that case was his daughter, who said, that's not daddy, that's not daddy. She was young. And so the family asked the doctors to turn the life support off, and the hospital refused. And because there wasn't an LPA in place, the family had to go to court. And again, some months later and a few £1,000s later, the doctor sided with the family and forced the hospital to comply with the family's wishes. On the right side, Bradley Visser, well, his wife did have an LPA. And then when she told the doctors to turn the machines off, they did, they complied. And hopefully you can see that circled in red. She was very vocal and said that if she didn't have this piece of paper in place, she doesn't know how she would have got out of bed in the morning. So if possible, it can be very heartbreaking and frustrating for families to be excluded from all these important decisions. So make an LPA and avoid deputyship as your only other option. So lasting power of attorney, well, what is it? Well, it's a 20-page document. It lists who the donor is. That's the person that's making the LPA, the attorneys, replacement attorneys. So you could have up to 4 attorneys and then up to 4 replacement attorneys. A typical example would be someone appointing their spouse as an attorney and their adult children as replacement attorneys. But you could also have them, all of them acting together. How they will act, jointly and severally, or whether jointly. Nominated people, we don't really use anymore. But this is someone that you write to so they can voice an objection. Most people don't want to alert someone who's going to voice an objection anyway. Certificate provider, this is somebody who does sign the document on your behalf. They are signing to say that in their opinion, the person who's giving the LPA understands what they're doing and they're not being coerced. Beyond that, they have no further involvement, any guidance or restrictions, and then you sign and it's sent off for registration. Okay. Court of protection figures are showing that it can take over a year to get a deputyship order, right? A lasting power of attorney takes around 8 or 10 weeks, and it's a lot cheaper. Okay, so don't burn your money going through the courts. Do it now. And really, I liken these documents to insurance, a bit like what Brian was talking about. If you take out a lasting power of attorney document, or if you give them to your family, The best possible scenario is that we never have to use them. You know, you spend your money, you put them in a drawer, and please God, they never have to come out. But if you do lose capacity, they are probably the best tools that people who love you and know what you want have to make sure that you're looked after in the way that you would have wanted.